Afternoon, everybody. The slides are up there now, and thanks to you, Roy, and indeed to Elva and your respective teams. As the title to this session suggests, myself and Nathan are going to discuss with you statutory processes for active travel schemes and sort of try to bring you through what statutory processes might apply and why. And I suppose just looking initially at the types of statutory processes that crop up when you're looking at active travel initiatives. Just on the screen there, we have Section 38 of the Road Traffic Act 1994, which, as we know, is traffic calming measures. Beside that then is Section 95, which we'll be touching on also, of the Road Traffic Act 61, which is in relation to traffic signs. Those two provisions are executive functions, but I will come back in a little more detail on Section 38 in relation to that particular issue. Then we have Part 8, which most people will be familiar with, local authority owned development under Part 8 of the Planning and Development Regulations 2001. As we know, that's a reserved function of the elected members of the local authority. And then we have three other provisions in which you may end up looking for development consent. The first there is Section 51 of the Roads Act 1993, which is really for large road infrastructure developments. The second is Section 177AE of the Planning and Development Act 2000 as amended, and that is where in effect it's a local authority owned development that requires an AA only, an AA being appropriate assessment only and not an EIA. And then the third is Section 175 of the Planning and Development Act, which is where it's a local authority owned development that requires an EIA-R. And all of those are applications that, as you'll see from the screen, go direct to onboard Planola. So then before getting into a discussion on any of those, I just thought I'd bring you through a couple of examples of initiatives that are out there and potentially in the newspapers at the moment, and some of which also have legal challenges pending. The first there is Strand Road Cycle Route. That was, they used Section 38 traffic calming measures. And as we've seen, it's been discussed quite a bit in the newspapers and is subject to legal challenge by way of judicial review. As we understand it, those proceedings were held, the judicial review proceedings were heard in the High Court last Thursday, Friday, concluded this Tuesday. Judgment in that case has been reserved, but we understand the judge has indicated he tried to be efficient with the decision. Interestingly there, a stay, which is in effect a stopping, was granted in relation to the implementation of that cycle route, pending the court determination, whenever that may be. The sort of allegations that were coming up, as we understand it from what we could read in reports, etc., was that an allegation in relation to Section 38, that it didn't take into account all road users when you're looking at the safety and convenience, but more focused on cyclists. We understand there's some allegations that really this should have been a Part 8 under the Planning and Development regs and therefore open to greater public scrutiny. We understand there's all sorts of allegations, and we'll be discussing this issue later in some detail, all sorts of allegations about appropriate assessment screening, whether it was done correctly, whether it was done at the right time, and indeed whether there was an actual appropriate assessment screening determination done by the council. And we also understand, and it's something I'm going to touch on later on as well, is there were allegations about Article 9A, which mightn't, you know, isn't the most familiar of articles in the EIA directive, but it's an article that suggests and requires competent authorities to perform their duties under the directive in a manner that doesn't force them to engage in conflicts as such. And we'll come back to the conflicts piece much later on, I think, when I finish out on screening. Another scheme that again hit the news on Monday in the newspapers was a traffic calming scheme in Malahide, which was simply a pedestrianisation, as we understand it, of New Street Malahide. Again, reliance upon Section 38 of the 1994 Act, and I see from the newspapers on Monday that that's the subject of judicial review and indeed an application for an injunction. So there were two Section 38s traffic calming. Another example is South Kerry Greenway. It's a road development under Section 51 of the 1993 Act, And you'll recall my first slide suggested that's an application straight to An Bord Pleanála. It is a fairly large scheme. It's I understand, 32 kilometres. And the cycleway caters not just for cyclists, but also for pedestrians. Again, subject to judicial review. So sorry to be telling you all the ones that hit the courts. I understand it from, again, newspaper reports. It was heard very recently, late in June, and a decision is awaited. In terms of allegations, there's some ecological allegations about the Kerry slug and bat species, allegations of project splitting, I think, against An Bord Pleanála, where I understand they may have dropped a section of the scheme and yet didn't revert to Kerry County Council, nor did the allegation is, nor did they assess the impacts of that. And there are various CPO issues, I understand, raised by local farmers in that case as well. Then to give you a flavour of some Part 8 stuff that's out there, this is just simply a cycle bridge in Donabate, or sorry, a pedestrian and cycle bridge done in Donabate, which I understand is over the Dublin to Belfast railway line, and that Part 8 was used there for that project or bridge. The next one is just one in Kildare, which is just a 4 kilometres addition, I think, between the 12th Lock and Hazelhatch Bridge, being part of the Grand Canal Greenway. And then finally, we mentioned also in the first slide, section 177 AE. So this was the Wexford to Kirklow Greenway, which was obviously raised SAC issues in terms of appropriate assessment and triggered appropriate assessment, but didn't trigger an EIA or an EIA, and therefore it went to the board directly under section 177 AE. Unfortunately, as I understand it, that was refused by the board, where it couldn't rule out adverse impacts on the integrity of the sites. So you'll see there the various things that fall under various different statutory processes. And I guess then to try and step back and say, well, how do you determine what statutory process of those that I've mentioned to date, and there will be more I'll mention later on, which of those do we fall under and which must we consider? And I think to do that, you have to start with trying to figure out, well, what am I doing here in terms of the works or measures that are proposed to be implemented? And also, though, what about my environmental assessments? And do I have to do any screening? And how do I figure out whether I have to do screening at all? And when I mean screening there, I mean screening your works, measures, initiatives, project, whatever you want to call it, but we need to be careful what we call things, I guess, whether you need to screen it for environmental impact assessment or appropriate assessment. And you'll see there that slide is just explaining the type, you know, if it's only an EIA, you might go one route, only an AA, you might go another route, etc. So then just, I'm going to, I guess, have a little look with you now at some of the environmental assessments. And I'll use that term broadly enough to capture both environmental impact assessment, so that's EIA, and appropriate assessment, AA. And I'll refer to them going forward as EIA and AA, if that's okay. And I'm going to spend a little bit of time on these, I think, because they're the issues that raise most difficulties, I suspect, for practitioners and lawyers alike, and also they're the issues that probably create most litigation. So we've just set out the EIA screening test and the AA screening test there. I suppose firstly, just to say there's obviously some projects that you never even have to think about screening, whether it's EIA or particularly EIA, they're just automatic. So the stuff under the Roads Act, you take motorway service areas, etc. They're just automatic and you never have to turn your attention to whether you need to screen or not. They're going straight to the board regardless. But when we're looking at screening, both in EIA and AA, we really need to look at, well, what do we have to screen for? And this is where you have to screen for a project. And I have project in red there because it is a red alert thing as to whether you need to screen or not. And screening is required for a project if you are a project, whether or not it's exempt development and regardless of the development consent procedure you might use. And I guess if you screen in, well, that will determine in either EIA or AA, that will determine the consent process you have to follow and will rule out some other consent process. But I'm going to focus a lot today on screening and why you might have to screen a project. So we need to look at then the definition of project. And I guess the EIA directive defines projects. I'm looking at EIA screening here. It defines project as the execution of construction works or other installations or schemes, other interventions in the natural surroundings and landscape including those involving the extraction of mineral resources. And obviously the latter there, extraction of mineral resources, hopefully shouldn't bother us for this session. And then we need to look at, well, it says construction works. So we need to ask ourselves, well, is my initiative, my measure, what I'm proposing to do, involving some level of works that could be construed as a project for the purposes of the EIA directive? And the term works isn't unfortunately defined in the EIA directive, but there is a fairly decent definition of it in the Planning and Development Act at section 2. And what works is, it includes any act or operation of construction, excavation, demolition, extension, alteration, repair, or renewal. There's another limb to that which talks about protected structures, but I wasn't going to focus on that today. And also just to bear in mind, I guess, that, as I mentioned earlier, screening of a project applies really regardless of whether you think you might be exempt development or you think you know what consent process you might fall under, because screening might determine otherwise for you. And then in terms of how we get there, how we consider, well, are we a project that falls into the box of EIA screening? And we can take some guidance from the classes of projects and thresholds that are set out in the EIA directive, and they're outlined in Annexes 1 and 2 of the EIA directive, but equally they've been transposed into Schedule 5, Parts 1 and Part 2 of the Planning and Development Regulations. And I suppose there are 4 possible scenarios I'm going to refer to arising from consideration of these classes of projects and thresholds, and they will dictate where you might go next in your statutory processes consideration. So what parts 1 and 2 is, they list various projects. And I'll explain that the first scenario is if a project falls within the classes of projects that are listed in Part 1 of Schedule 5 of those planning regs, then you're automatic EIA, or you don't need to think about things. You're in, and that's it, and you're going to the board. The second scenario is your project that fall within any classes of projects listed in Part 2 of Schedule 5. And there are various thresholds set out there. And if you meet or exceed those thresholds, again, you're automatic EIA. You're in, you're going to the board. The third scenario is if you fall within any of the classes of projects listed in Part 2 that have a threshold, but you don't meet or exceed that threshold, i.e. you're below it, you must then screen for EIA. So you're not automatic, you must do a screening. And the fourth scenario is that recent case law suggesting that if you're not a project in either Part 1 or Part 2, then you don't trigger EIA or EIA screening. And I suppose just to pause there to note, and we have the note at the bottom of this slide, is that you won't find proposed road developments in Part 1 or Part 2 of the Planning and Development Regulations, because when you're in the proposed road development world, the directive was transposed in the Roads Act 1993 in relation to those type of proposed roads developments. And I might touch on that later if we have a little bit of time towards the end. And then, well, so there's this list of projects and there's classes and thresholds, etc., in the Planning and Development Regulations. Well, what might be most relevant to active travel schemes? And I think the one we see coming up time and time again is Class 10, bracket B, close bracket, bracket Roman numeral 4, close bracket, which is urban development. And urban development, it's under a heading infrastructure projects in Part 2 of Schedule 5 of the Planning and Development Regulations. Well, what does urban development mean? Well, good question. What the regulations say is that it involves an area greater than 2 hectares in the case of a business district. And just to pause there, what's a business district? Well, thankfully it is defined to mean a district within a city or town in which the predominant land use is retail, or commercial use. Goes on then the definition of urban development to say, or 10 hectares in the case of other parts of a built-up area. So therefore, the other parts being non-business district ones that are predominantly retail or commercial, and otherwise 20 hectares elsewhere. And I guess we'd all be scratching our heads, right, what does that mean? And there's some guidance out there. The EU Commission guidance of 2015 referred to projects for integrated urban transport schemes, such as parallel works at different locations to upgrade, for instance, bus lanes, tram lines, bus, tram, and or metro stops. But equally, that guidance also mentioned more substantial things like cinema complexes, housing developments, car parks. More recently, the Office of Planning Regulator guidance, which might be much more relevant to what we're talking about here, said in a document it published on EIA screening generally, that under the heading of urban development, it talked about public realm improvement schemes, but does say that many of those are schemes which would be subject to a Part 8 process if an EIA were not required. And I suppose just to flag to you that some of the judicial reviews that I've mentioned earlier do raise the issue of urban development. I know it came up in the Strand Road case, for instance, as I understand it. And then just, I suppose, to recall that from when I was talking about the thresholds. So if you do fall, or some of your measures or initiatives or whatever you want to call them, fall within urban development, but are below the relevant threshold, whether it's 2 hectares in a commercial retail area, whatever, they're then called sub-threshold development, and EIA screening is required. And just to pause there on one thing that sometimes crops up, excuse me, which is this concept of preliminary examination. Article 120, just when we're talking about screening, it's a preliminary examination for EIA. Article 20 of the regulations sets out a process for preliminary examination for EIA. It was introduced, I understand, in the 2018 regulations. It seems to only relate to Part 8, although the section at the start, or the Article 120 at the start, would lead you to believe it was referable to all local authority development, but the position, I think, is unclear. And also just to note that preliminary examination process isn't, in my view, set out in the EIA directive. So when you're looking at your initiative, your measures, your works, and if they're a very minor or trivial nature, it's really important that you make sure you document that and evidence that, so there's no allegations against you that you might be falling under urban development and therefore required screening if you were sub-threshold. And then in relation to, well, if you do have to screen, so you've looked at your projects list, you think, oh, maybe I do fall under one of those, but I'm sub-threshold, I'd better screen. Well, what does that involve? So you need an EIA screening report, and that has to be prepared following the criteria in Schedule 7 of the Planning and Development Regulations, and has to include the information in Schedule 7A of the Planning and Development Regulations. And they're all pretty much taken directly, bar 1 or 2 slight tweaks, from Annexes 2A and Annex 3 of the directive. Mitigation measures can be taken into account for EIA screening, and you'll see later that's very, very, very different when it comes to AA screening. You need to do a formal EIA determination, and absolutely you must include in that reasons for the determination you've arrived at. The EIA and all of this, the determination must all be done before you decide to implement the works, the initiatives, whatever. So it has to be done pre, and you need to make this available to the public. And also then just a flag, I mentioned earlier, this Article 9A issue that's cropping up about conflicts of interest, where the competent authority is equally the developer, like in local authority development, that doesn't go to the board. And I'll come back to that again later, but just to keep it in your minds. Again, Article 120 has this provision where members of the public can make an application to our board planola for a screening determination itself, probably if it doesn't accept the one the council has made, within 4 weeks. But the connection again is up to a Part 8 notice. So that is just a little quirk as to whether it refers to all local authority development, even those that wouldn't fall under Part 8. Again, that's unclear. I find Article 120 a bit unclear. So that's the EIA screening process that we need to turn our attention to. We also then need to turn our attention to, well, appropriate assessment. And that involves really assessing whether a plan or project is likely to have a significant effect on a European site. A screening for projects or plans is required under Regulation 42 of the Habitats Regulations, which is the regulation that transposed the Habitats Directive into Irish law. And there's also provisions under Part XAB of the Planning and Development Act itself. And I suppose we're back to project, but we're equally back to planning a project. I've just focused briefly on a project here. And just to flag that the courts generally take a fairly broad interpretation of these terms in the courts. So you never know which way it's going to turn out for you, whether you're a plan or a project or not a plan or a project under screening. But they do tend to err on the side of caution when it comes, as we know, unfortunately, to environmental matters, or maybe fortunately. A project is defined, sorry, it's not defined, should I say, in the directive, but thankfully the Irish regulations does give us good guidance and does define project as being including land use or infrastructural development, including any development of land or on land. B is all about the extraction of minerals, so we've left that out, but C is very general there. It says, or any other land use activities that are to be considered for adoption, execution, authorization, or approval by a public authority, and public authority is defined, which includes local authorities. And I suppose, just reflecting on that, well, at least we had a list of projects in the EIA directive, or the EIA regs, or the planning and development regs that transpose the EIA directive, which at least to things like urban development. Here you don't have much guidance. You have whatever the courts have told us, and you have this definition of project. And I guess the word of caution is many measures or initiatives that one might be doing may be regarded as development of land or on land or land use activities that are to be considered for execution by a public authority, and so arguably a project for the purposes of AA screening. I haven't mentioned plan there, but I might just briefly mention it. Its definition, it's also contained in the Habitat Regulations, and it's any plan, program, or scheme. It can be statutory or non-statutory. And what it does is establishes public policy in relation to land use and infrastructure development in one or more specified locations or regions, including any development of land or on land. Now, there's a bit more expansion to that definition, but again, pause for thought. A plan may well be a non-statutory plan, program, or scheme that establishes some level of public policy in relation to land use or infrastructural development in one or more specified locations. And you could then be a plan that, if challenged, the courts may decide, well, actually, it did require a screening. And then back to, well, so I have to consider my EIA screening and my screening, my EIA screening determination. Similar here, if you have to do AA screening, what's involved? What does it entail? So again, similar to your EIA screening, you have to prepare an AA screening report, generally done by a specialist ecologist. Mitigation measures, very, very, very different here. They must not and cannot be taken into account in AA screening. And I'm just going to pause there because it causes a lot of litigation and a lot of debate. Couple of notes on mitigation measures. Firstly, there's still debate about and a lot of debate about as to what amounts to a mitigation measure. And indeed, the Court of Justice in Europe even said, look, that label isn't anywhere to be seen actually in the Habitats Directive. The second thing to bear in mind is it's not just that the measure, it's not a matter of the measure being integral to the project rather than merely additional. That doesn't work for us anymore. The question you have to ask yourself is whether the measure can be said to have been intended to avoid or reduce harmful impacts on a Natura 2000 site, or whether you could safely say the measure was actually designed solely for some other purpose. The third thing to bear in mind with mitigation measures is you really need to look at it on a very objective basis, and that's exactly what the courts will do. We had some, the fourth point to make, sorry, and that is we had some comfort and examples as to what exclusively and solely for some other purpose meant up to recently, when we knew that the courts had previously held that sustainable drainage systems such as SUDs were in the clear. You are allowed to take them into account in AA screening. They were standard drainage designage systems. They were and required with very limited exceptions in most new developments, and they were standard wear really regardless of proximity to a European site. But now, very recently, that itself now has been thrown into doubt, because there's been a recent reference by Judge Humphreys to the European courts as to whether SUDS in fact is a mitigation measure or not, and whether it can be taken into account or not in AA screening. So be a while before we're waiting for that. So that's throwing the cat amongst the pigeons in AA screening. And the fifth point on mitigation measures is obviously to be careful if you're doing AA screening and EIA screening. Mitigation measures, there might be a mitigation measure, you can take it into account for one but not the other. So they're very different, but you just have to bear that in mind, how mitigation measures are treated. Back to then, what does your screening process entail? You need to, after you've done your screening report and not taken mitigation measures into account, make a formal appropriate assessment screening determination, again, with reasons. Your determination must be made before you make your decision, and it must again be made available to the public, so inspection at your offices and on the website. While there's no mandatory, as I say at the end of this slide, public consultation requirement in respect of AA screening, we think at some stage this challenge will come in a successful way. It has been challenged, we understand, again in the Strand Road case. We'll see how much traction it may get, but at the moment it's not there in black and white. Then, so you've spent an exhaustive amount of time now considering with what your initiatives or measures, whether they're a project for EIA purposes. You've considered whether they're a plan or project for AA purposes. You've looked at whether you're automatic EIA and therefore go a particular route in your statutory consent process. You've thought about what your result of your AA screening is, and if you're in, you're going a particular direction. And in terms of going screening in, you'll see there, as we mentioned at the start, if you're EIA only, you're section 175. If you're AA only, you're section 177 AE. And if you're both screening in for EIA and AA, you're going a combination of 175 and 177 AE. And just to pause there to say, up at the top, we say there, that excludes proposed road developments under section 50 and article 8. And then I guess if you screen out, however, which is where we generally want to be, the benefit of screening out is it really unlocks entry into a category of exempt development. And I think it's just worth pausing on what the definition of development is under the Planning and Development Act. And it says, as we know, the carrying out of any works under any land, or the making of any material change in the use of any structure or other land. And I guess to answer the question as to, well, what constitutes development generally, I think you need to consider the following questions. What physical works, and we know works was defined from earlier, are involved, and how material are they? And is there a material change to the permitted use? Is there a change to the permitted use, and could that be material? And in terms of exempt development, we're quite familiar with these. It's generally development to be carried out by a local authority in its functional area, or I just put in the word there, the other one there, that's classic about a local authority carrying out maintenance or improvements in its road network. But even if you're exempted development, so you've screened out and you're thinking, right, I'm exempted development under section 4 of the Planning and Development Act, it sort of doesn't stop there. There may be other planning controls that could apply, and therefore we're going to look at some of those planning controls, because circling back, there's some of those planning controls that are being relied upon for certain active travel measures. And the 4 we're going to look at is section 38, traffic calming measures, section 95, signs, that Nathan's going to deal with, part 8 that we're all familiar with, and then just at the end to mention section 138 of the Local Government Act and what that entails. Then looking at each of these in turn. Section 38, classic traffic calming measures. It said a road authority may. So we're in the interests of the safety and convenience of road users. So it's safety, convenience of road users. We can provide traffic calming measures, and we'll come to that definition in a moment, that they, being the road authority, considers desirable in respect of public roads in their charge. And also, obviously, you can remove traffic calming measures also. And just to flag also, the NTA have power in the Public Transport Regulation Act for traffic calming measures also. Road authority as well obviously includes a local authority, county council, etc. So what's traffic calming measures? Well, the first part of it is measures pretty much that are to enhance the provision of public bus services, and then including measures to restrict or control access to a road or part of a road by mechanically propelled vehicles, but again for the purpose of enhancing public bus services. So A there is very focused on public bus services. B is somewhat wider. It's measures that restrict or control the speed or movement of, or which prevent, restrict or control access to a public road or roads by mechanically propelled vehicles, and measures which facilitate the safe use of public roads by different classes of traffic, and importantly it says, including pedestrians and cyclists. And then all of that, so that's definitely much more general and probably is much more relied upon in active travel measures that aren't related to enhancing public bus services. And included in that then, for the purposes of the above, you have all the things like traffic signs, road markings, chicanes, bollards, etc. So in terms of the procedures under Section 38, and there's certainly some confusion out there in relation to this, there are definitely requirements to be followed if you're a prescribed type of traffic calming measure, and specific procedures apply when you are a prescribed type, and that's why prescribed is in red there. And they include, and I'll just run through them very briefly, it's consult with the Commissioner of Garda Síochána, publish notice in the newspapers circulating in the functional area, indicating what the proposed measures are, advising the representations can be made in relation to it from the public. Then you need to consider the observations from Garda Síochána and indeed the representations from members of the public. And then any decision in relation to those prescribed traffic calming measures is a reserved function of the elected members. But very importantly, we can't find any statutory instrument that suggests there were any traffic calming measures that have been prescribed. And prescribed is defined in the Road Traffic Act 1994. And therefore, so what's the result of that? Well, then there's no specific statutory procedures or public consultation required for Section 38. But of course, there's responsible local authorities would always recommend some form of non-statutory consultation would be a good idea with your local residents, local businesses, other stakeholders, and indeed your elected members themselves. And then in relation to traffic signs, I'm going to hand over to Nathan, who's going to just run you through some of the provisions. So this is the second planning controls we've done with traffic calming measures. And a lot of the time with traffic calming measures, you'll also have to implement signs or put up signs, etc., that will complement your traffic calming measures. But in this, indeed, this can stand in its own right as well. So Nathan's just going to talk you through a couple of slides in relation to this.
Thanks, Michelle. So Section 95 of the 1961 Act gives the road authority a power to provide traffic signs in respect of public roads in its charge. And it divides traffic signs within the section into three broad categories, and many of you will be familiar with these categories from the traffic signs manual and other documents. But in general terms, you have information signs, which might be directions or, and then the third category, which is probably the most relevant for some of what we're talking about here, is regulatory signs, and we'll come to what the section says in relation to regulatory signs in a moment. But just to note, you have different requirements in relation to, on the one hand, information and warning signs that a road authority may wish to provide, and on the other hand, regulatory signs. So with information and warning signs, it's essentially left to the discretion of the road authority, so they can provide, in respect of public roads in their charge, such information and warning signs as they consider desirable. But then you have additional requirements in relation to regulatory signs, where you can only provide those signs after consultation with the Commissioner, and that's the Commissioner of Garda Síochána. And we'll come in a moment to some other functions that the Commissioner has in relation to regulatory signs as well. But just to look at what is a regulatory sign and what does a regulatory sign achieve, the Act says that a regulatory sign indicates the existence of a road regulation or implements such a regulation or both, or indicates the existence of a provision in an enactment relating to road traffic. So to put some context on that as an example, a pedestrianised street sign is a regulatory sign, and it's a sign you might use in an active travel scheme. And in relation to that sign, Article 45 of the 97 regulations provides that essentially a person shan't drive into a portion of a road where that sign has been provided. And so if the road authority uses its Section 95 power to provide that regulatory sign after consulting with the Commissioner, that sign then indicates the existence of Regulation 45 and it implements that regulation. So the effect of having provided the sign under Section 95 is that that road or part of a road is pedestrianised and a person shall not drive onto it. And then, as I mentioned, the Commissioner has some additional powers or functions in relation to regulatory signs. So he can request that certain regulatory signs be provided or moved or removed by the road authority. And of course, the road authority has to comply with the Commissioner in that. And also just to note, as you know, and as Michelle mentioned, you can use your Section 95 powers in conjunction with other powers. So if we stick with the pedestrianised street sign as an example, you might provide the sign under Section 95, and at the same time, as part of your pedestrianisation, you might do other things, be that bollards or whatever it might be, in the context of Section 38, and using those powers. And of course, when you're doing that, you can't just look at Section 95 in isolation. You have to look at the whole picture, consider all of your other statutory requirements we've been talking about, and look at it in the overall context of what you're doing. I think I'll hand back to Michelle now, the next planning control.
Yeah, thanks, Roy. If you can turn me back on there.
Yeah, I can hear you, Michelle. Go ahead.
Okay, great. Thank you. So then the third planning control that we want to just briefly mention, because it'll be the most familiar of them, I think, is the Part 8 process. Most local authority exempt development is carried out under Part 8 of the Planning and Development Regulations. It's not it's not a development consent, as there's no consent per se that's required or granted by any consenting authority. It's, as we know, a reserve function of the local authority. There's a public consultation process. The chief executive prepares a report to the elected members, and that must consider all of the submissions received from the public, as well as then deciding whether the chief executive is going to recommend whether or not the proposed development should be proceeded with, and proceeded with as varied or modified as recommended in that report, or indeed whether it shouldn't be proceeded with. The elected members then have an obligation to consider the proposed development and indeed the chief executive's report. And then after that, it's the elected members that really decide, after they have an obligation to consider the report, whether the proposed development should be carried out as recommended, or whether it should be varied or modified, or indeed not proceed at all. And then, as you know, under Article 80 of the Planning and Development Regulations, it lists the type of classes of development that fall within Part 8 or that are covered within Part 8. And two we've just picked out of that, which is about the construction of a new road or widening or alignment of an existing road. They're nothing like the ones you'll see in the Roads Act or indeed the road regulations. They're much smaller developments, such as in the case of a road in an urban area, 100 metres or more, and in any other area, a kilometre. And the one probably that catches is the catch-all one, is anything really that's not specified earlier in Article 80, but where the estimated cost exceeds €126,000. So therefore, just to pause for 2 minutes on the main differences between Part 8 and 38, being the traffic calming measures. Part 8, a reserve function. Section 38, non-prescribed traffic calming measures, is not. And Part 8 dictates statutory public consultation. Section 38, non-prescribed traffic measures, does not. And then just very briefly going through disapplication of Part 8. Obviously, it can't apply where you're in EIA or AA world, but two other interesting ones. One is Section 179(6)BB, as shown on the screen there, where it consists of works other than, though, be careful, involving road widening, that enhances public bus services, or this time also improves facilities for cyclists, and that's under 95 or 38, so it shows the relationship between the two. And then there's this other one really, which is in for emergency situations under section 1796B, where it's necessary for dealing urgently with any situation which the chief executive considers as an emergency situation and needs immediate action. So that's the third planning control. The fourth, then, just to mention briefly, is the obligation under section 138 of the Local Government Act. And that's just exactly as it says on the tin. In fairness, in the legislation, it just says there's an obligation on the chief executive to inform the council, that's the elected members, before any works, and it's other than works of maintenance or repair, are undertaken. And also then under section 39, the elected members may by resolution, however, direct the chief executive not to proceed with those works. So it's focused on works, as we know, which has a definition under the Planning and Development Acts, and it's works other than works of maintenance or repair. And then just some miscellaneous matters, if we have time, Roy, to quickly cover is obviously always remember, if you're implementing a measure or scheme, you must do so in compliance with your development plan, or certainly you cannot carry out development that materially contravenes your own development plan. And that then just might cause you some pause for thought to ensure that somewhere your relative objectives in your development plan would be used or would cover. And it clearly, your development plan can't cover every minutiae of a measure, but once it's generally covered, you should be safe enough. And the issue then I wanted to just return to was this whole issue I mentioned a couple of times about this Article 9A allegation that we see sneaking into proceedings. And it's, I think, no harm just to read out 9A there, if that's okay, where it says member states shall ensure that the competent authority or authorities perform their duties under the directive in an objective manner and don't find themselves in a situation where they're causing a conflict of interest for themselves. But interestingly, it does go on underneath that to say, where the competent authority is also the developer, member states shall at least implement within their organisation of administrative competencies an appropriate separation between conflicting functions when performing their duties. And I just also included recital 25, which is useful to inform what that might mean. And I think going on to what we think that means, there's going to be an argument out there, I think, and it is out there in live, that there's an inherent conflict of interest when a body acts as both developer and the competent authority on deciding on the development proposal, but not just on the development proposal, also on the screening for EIA or AA. And that's, as I say there on the slide, we understand was brought up in the Strand Road proceedings, and we also understand was raised in two other sets of proceedings, the Save the Cork Community Association and the Ballyboden Tidy Towns, which are still pending before the High Court. And I guess in our view, Article 9A seems, from what I've read just earlier, to accept that the competent authority can be one and the same as the developer, but what Article 9 view requires is a functional separation between the persons proposing the development and the persons carrying out the screening. So have separate entities or bodies or committees within your council doing the different things and functionally separate from the other. And however, obviously, we don't know if our view on that is going to be right until we see what might come out of some of these cases, but we think at least it puts up a good defense. So then in summary, I guess, trying to bring you back through all of that, we think that a good starting point when you're doing any initiatives is to think about, one, what you're doing, but secondly, consider your environmental assessments, which includes both EIA and AA, because they're the matters that in fact are going to dictate potentially what statutory process you have to go down. Just to recap, if you screen in, again, this is non-Roads Act stuff, your section 175 if you screen in for EIA, for AA your 177 AE, and for both the EIA and AA your 175 and 177 AE, and you can do them together. You don't have to do two notices or two applications. It's one application and the Act provides for that. If you screen out, you unlock exempt development, but it doesn't stop there. You need to think about your planning controls under your traffic signs, your traffic calming measures. Are you a Part 8? And then always remember, even if Part 8 is disapplied, Section 138 and your obligations under that. And then finally, I said if I had time, and I have very little, I think, left, Roy, I just quickly cover road developments under the Roads Act, which aren't covered under the planning and development regulations that I've been talking a lot about for the last 40 minutes or so. But for road projects, EIA is automatically required, and the easy ones are motorway, busway, service area. However, the Roads Act also said, well, the government might prescribe things that should be included also, and they did bring in other types of road development that are automatic EIA, and they were brought in Roads Regs 94, and they are things that, and I think it's really important, the definition, it's road development consisting of the construction of a proposed public road or the improvement of an existing public road, and A then is the one you've probably come across most, which is the construction of a new road, 4 more lanes, or the realignment or widening of an existing road so as to provide 4 more lanes, which are, when widened or realigned or new, would be 8 kilometres in a rural area or 500 metres in length in an urban area. And then the other provision that's automatic is a bridge or tunnel of over 100 metres, but it doesn't stop there, because the Roads Act says in section 50, where you're considering a road development, it doesn't define what road development is, but we know what development is, and we know the road is defined very widely in the Roads Act. You need to turn the switch on. You need to consider, well, what I'm doing is not automatic, but I need to do a screening. I need to consider, could this have likely effects on the environment? And if it did, I need to do an EIA, and there's a process you need to follow then in going to the board and informing them that. So that's it, Roy, really very briefly, to try and close out the Roads Act piece at the end.